Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Well, hi, everyone. Welcome to today's podcast, Grid Evolution, Navigating FERC Order 1920. My name is Liz Vogel, and I'm the co-chair of the ABA SEER Energy Committee, and I will be the host of today's podcast. I am joined by Eric Runge and Margaret Seebiel of Day Pitney, who are both attorneys in Day Pitney's energy practice. Eric and Margaret serve as counsel to NEPOOL Transmission Committee and are heavily involved in all transmission planning matters in New England. In addition to their work in New England, they and their colleagues in the firm's energy practice provide legal counsel to several clients across the United States on various topics, including transmission, interconnection, and siting-related matters. Eric and Margaret, it's a real pleasure to have you both here today to break down FERC Order 1920. Over the next 30 minutes or so, we're going to explore some of the big changes that this regulation brings to regional transmission planning and cost allocation in the United States. And we're going to kick things off by looking at some of the key elements of Order 1920, including the new requirements for long-term regional transmission planning and increased transparency in the process. We're also going to be talking about the new rules for state involvement in cost allocation decisions and that are aimed at making project implementation smoother and faster. Plus, we're going to be discussing the directive for transmission providers to consider innovative technologies to really boost our energy infrastructure's efficiency and resilience. So hopefully throughout these next 30 or so minutes, we're going to give you a better and more clear understanding of how Order 1920 is set up to shape the future of our energy grid. And with that, let's sit back, relax, and let's dive into the transformative potential of Order 1920. Eric, I think you would be the best person to take question number one that I have, which is, when I'm reading Order 1920, one of the first key elements that really jumps out is the enhanced long-term regional transmission planning requirements, or as we've kind of dubbed it, the LTRTP process. As we consider some of the core components of the LTRTP process, what do you think are likely to be some of the key implementation challenges for Order 1920's LTRTP requirements?
All right. Well, thank you, Liz, and it's a pleasure to be with you and the listeners today. So as you suggest, the LTRTP requirements are really the heart of Order 1920, and they are mandated for all FERC jurisdictional transmission providers. And by long-term, FERC means a planning horizon of at least 20 years forward. So let's just take a step back and provide some context. The requirement for LTRTP is based on the FERC's findings that in the absence of long-term, forward-looking, and comprehensive regional transmission planning, transmission development tends to be done in a piecemeal fashion, and that's less efficient and less cost-effective, and therefore results in transmission rates that are unjust and unreasonable. So that's really the basis for the mandate for transmission providers across the country to do long-term regional transmission planning. Now, as to what LTRTP involves, there are several important elements to that process and its requirements, but the key ones, I'm going to list these here, are first, the use of at least 3 plausible and diverse long-term scenarios to identify long-term transmission needs and to evaluate potential solutions to those needs. So it's a scenario-driven process, and there's a prescriptive nature to these scenarios. They have to be 3, and they have to have certain things in them. So the second requirement is that transmission providers must include 7 express categories of factors to be in those long-term scenarios. Now, these categories include items such as federal, state, and local laws and regulations affecting the resource mix and demand, and laws and regulations regarding decarbonization and electrification, resource retirements on the system, and generator interconnection requests, just to name some of those 7 categories. A third important element of the LTRTP is the use of specific categories of benefits to evaluate and select solutions. So again, the Commission is pretty prescriptive here. It gives you those categories that must be included. And they include things like avoidance of the need for short-term reliability, transmission upgrades, production cost savings, reduced congestion on the system, and energy losses, to name some of them. A fourth important element is the transmission provider's required interaction with relevant state entities on several matters, including the development of the scenarios, the transmission solution evaluation and selection, and cost allocation. Fifth is a robust, open, and transparent stakeholder process throughout the planning process. This is something that FERC has already required for transmission planning under Orders 890 and 1000, and it certainly continues here. And sixth, there is a competitive process required for proposed solutions to the identified needs. Now, there are many other details of the process and the requirements for this long-term planning, but these are some of the key ones. So now with these core elements in mind, let's turn to your question on some of the implementation challenges that lie ahead. And there will be many such challenges as we get into the details of compliance proposals and actual implementation, but let me quickly just list 7 of them. First, integrating the new LTRTP process with existing planning processes and figuring out whether they overlap and how to deal with the overlap will be a challenge. So some of those processes are in place right now under Order 890 and Order 1000. They look at usually a 10-year planning horizon, and they look for reliability and economic and public policy needs per those orders that I mentioned. And they're often addressed in a segmented way. So transmission providers will have to figure out how to coordinate those processes with the new LTRTP without inefficiencies and without disrupting what comes out of each process in terms of potential solutions to identified needs. It's also the case that some regions have filed or already have in their tariffs provisions for longer-term planning or some kind of state agreement approach with a lead role from the states. For example, this is the case in PJM and ISO New England. PJM has a state agreement approach in its tariff for some time now, and ISO New England has a longer-term planning proposal that is in front of the Commission right now pending approval. And that's expected, an order is expected by July 8th for that. So in these cases, the transmission provider and interested stakeholders will have to carefully coordinate those existing processes with the requirements of Order 1920 or seek appropriate deviations from the pro forma requirement. Second, regarding the development of the long-term scenarios, it could be challenging for a region to agree on what the minimum 3 long-term scenarios will be and making sure they are a plausible and diverse set of LTS. And given this challenge, we could well see more than 3 of these scenarios develop, or multiple sensitivities applied to the 3 LTS, making for a more complex analysis with more associated time, effort, and expense. Now, the transmission provider makes the final call on the scenarios, but there could be quite a bit of back and forth before that happens. A third, and related to the second issue, agreeing as a region on the specific factors that will populate the 7 required factor categories in each LTS could be a challenge. Remember, Order 1920 requires use of 7 categories of factors, but populating those categories with specific factors is up to the transmission provider with input from the states and the other stakeholders. Fourth, Order 1920's requirement that proposed solutions be evaluated based on the multiple required benefits categories could also present difficulty in implementation, with disagreements over the weighting of benefits or their applicability at all to a particular solution. Fifth, Order 1920 gives the states a significant role at various points in the LTRTP process, but it stops short of giving them any decisive role, except to some extent on cost allocation. The lack of state control over the planning process for public policy upgrades under Order 1000 has led to a complete lack of use of that process in some regions, with New England being an example of that. With the LTRTP process, there is at least a concern that implementation of it in some regions could be hindered by insufficient state control over some aspects of the process. I think we've seen that reflected in requests for a hearing. Sixth, the focus on transmission planning for long-term needs is inherently fraught with considerable uncertainty and risk regarding whether the future will be as projected. This uncertainty and the potential need for reevaluation provided for under Order 1920 will itself present a challenge to selecting and actually developing solutions to identified long-term needs. And finally, regarding implementation challenges, Order 1920 retains much of what is in Order 1000, including competitive development of regional transmission solutions, with the exception of certain in-kind replacement projects, but there is really very little discussion in the order about the competitive solution process itself. And the lack of more specific guidance on this topic could result in some disputes or at least inefficiencies down the road. So with that, Liz, I'll conclude for now.
Oh, wow. Well, thank you so much. That was definitely very informative. So thank you, Eric, for that and taking the time to lean on the response to that. I think one of the other issues that I was having when I was reading through Order 1920 and just doing some research online and seeing what's coming out about it is really the difficult subject of cost allocation and how that's going to work. Margaret, I was hoping that you might be able to address two of the questions that I have in regards to cost allocation. The first being, how does Order 1920 address cost allocation for long-term transmission regional facilities? And then on the other side of things, what is the commission aiming to achieve through what they're deeming the state agreement approach? And is that approach described in Order 1920 likely to be successful?
Thank you so much, Liz. It's great to be with you today. You're certainly correct that the cost allocation component of Order 1920 is a difficult subject. Order 1920 directs transmission providers to develop a default ex-ante long-term regional transmission cost allocation method, meaning a method that is based on forecasts or predictions, with the opportunity to potentially include a state agreement process. So I'll first talk about the details of that default ex-ante approach. So the Commission required that any long-term regional transmission cost allocation method, which is a mouthful, would need to satisfy 5 of the 6 existing Order Number 1000 regional cost allocation principles. And these are principles that FERC found to be important when it issued Order Number 1000 several years ago. So those 5 principles are, first, that costs are allocated to those within the transmission planning region that benefit from the facilities in a manner that is at least roughly commensurate with estimated benefits. Number 2, entities that do not benefit from transmission facilities must not be allocated costs involuntarily. Number 3, if the benefit to cost threshold ratio is adopted, it cannot exceed 1.25 to 1. Number 4, costs must be allocated solely within the transmission planning region unless entities outside the region voluntarily assume some costs. And number 5, the method for determining benefits and identifying beneficiaries must be transparent. So those are the principles that transmission providers must use when developing their long-term regional transmission cost allocation method. Those first 2 principles I talked about are the most important for the Commission here. The Commission emphasized that it would assess the methods proposed by transmission providers largely based on whether it allocates costs in a manner that is at least roughly commensurate with estimated benefits, looking at on a fact-specific basis. So unlike that default approach, the cost allocation method derived through the state agreement approach is not necessarily required to comply with those Order Number 1000 regional cost allocation principles. So let's dive a little bit deeper into the state agreement approach. The final rule, in addition to the default approach, also provides the opportunity for a cost allocation method that results from negotiation among the relevant state entities. And relevant state entities is a defined term in the final rule, encompassing state entities responsible for electric utility regulation or siting electric transmission facilities within the state. There were a couple of notes in requests for rehearing about that definition and how broad it is and who exactly in the states is going to be a relevant state entity. So we'll see if FERC provides a bit more clarity on that term because it is a pretty important term. The state agreement process that was established allows for one or more of the relevant state entities to voluntarily agree to a cost allocation method for the long-term regional transmission facilities within a 6-month time frame of when the facilities are selected in the regional transmission plan. Transmission providers must essentially provide a forum for negotiation and must describe how the state agreement process could result in a cost allocation methodology being filed with the Commission. Now, Eric kind of picked up on this in his first response, but the language the Commission uses is that transmission providers may file the cost allocation methodology agreed to by the states. The ultimate decision as to whether to file that state agreement methodology rests with the transmission provider. So where the majority of the Commission, Commissioners Clements and Chairman Phillips, were trying to set up an approach that considered state perspectives and created a forum for state negotiation on cost allocation, which is always a contentious subject, critics of the final rule have emphasized that transmission providers are actually given the final say on the cost allocation methodology. So whether the approach, as you asked, is likely to be successful is to be determined. While the Commission did uphold those cost allocation principles that we have seen since Order Number 1000 and the general, as we say, beneficiaries pay approach, it's unclear whether the state agreement process, as defined in Order 1920, will result in any new or creative cost allocation methodologies being filed with the Commission. But as Eric also highlighted, a few of these state agreement processes are currently being used in regions throughout the United States.
All right, excellent. Thank you so much for that. You mentioned in your answer to the questions on the cost allocation that there's been some rehearing requests already. So I'm curious as to your thoughts of whether or not there's other key legal challenges that are being made to Order 1920 and how likely they are to succeed on rehearing or even on appeal.
Yeah, this is a great question. And for any listeners, a rehearing request is kind of FERC lingo for parties that are asking the Commission to take another look at certain elements of the final rule. So they request rehearing with the Commission, and then after rehearing is either denied or the Commission will issue an order on rehearing, then they can appeal up to usually the DC Circuit. So this is very topical because on June 12th, about 50 parties requested rehearing of Order 1920. And this is not terribly surprising given the divided nature of the Commission on Order 1920. It was issued on party lines, but it is a fairly significant number of rehearings that the Commission will have to address. So without getting too deep in the weeds on the merits of the arguments raised, the largest group of entities that filed requests for rehearings were the states, state attorneys general, and state public utility commissions, largely from traditionally red states. I'll highlight just a few of the significant legal challenges. First, many of these states argued that FERC overstepped. They argue that Order 1920 is an unlawful usurpation of states' exclusive authority over generation under the Federal Power Act. They argue, as Commissioner Christie did in his dissent, and that the final rule is basically a thinly veiled attempt to push a renewable energy agenda and forces states that may not have the same renewable goals to subsidize public policies of other states in the same region. And on a constitutional note, due to the high-profile nature of the final rule and its significance, many of these states also raise the concern that the final rule violates the major questions doctrine and should accordingly be not something that FERC is able to regulate without more direction from Congress. As discussed earlier, it is unsurprisingly, these states also raise concern about the cost allocation approach and the state agreement process, arguing that it fails to give enough deference to the states and is, as we say in FERC lingo, unjust and unreasonable. As far as some of the other entities that requested rehearing, because there were others, a few transmission providers requested rehearing of the reevaluation requirement of Order 1920. I believe Eric mentioned this briefly in his opening comments. Given the number of requests on this point, we will almost certainly hear from FERC about the reevaluation requirement. So Order number 1920, just to recap, requires transmission providers to reevaluate selected long-term regional transmission facilities in certain situations. The three situations they outline in Order 1920 are: one, if there are delays in the development that would jeopardize a transmission provider's ability to meet its reliability needs. Two, the actual or projected costs significantly exceed cost estimates of the project. And number three, there have been significant changes in federally recognized tribal, state, or local laws or regulations, causing significant concern that a selected facility may no longer meet the selection criteria. So, parties requesting rehearing raised two main concerns on this reevaluation requirement. First, they raised that this was not really something that was present in the Notice of Proposed Rulemaking, or NOPR. In order to be consistent with the Administrative Procedure Act, the final rule needs to be a logical outgrowth of the NOPR, and there needs to have been an opportunity for notice and comment on the proposal. Several entities argue that because these specific reevaluation scenarios were not in the NOPR, they cannot properly be in the final rule. And second, these entities take issue with the substance of the reevaluation scenarios and state that they are unworkable, lead to increased risk, and would essentially require previously selected projects be consistently and repeatedly reevaluated, which would not actually further the goals of getting transmission planned and built. There were a few other big topics referenced in the request for rehearing, such as flexibility for transmission providers, the right of first refusal, the construction work in progress or QUIP incentive, and the 7 benefits, 7 factors test. So we will almost certainly see an order number 1920-A. The next step is going to be a notice from the Commission that denies the rehearing by operation of law. This is a requirement from a DC Circuit case so that entities requesting rehearings may timely bring their appeals to the DC Circuit. But that notice will not preclude the Commission from later reviewing Order 1920 and issuing subsequent orders 1920A, B, C, etc., once it has an opportunity to fully review the request for rehearing.
Well, thank you so much. I do like the FERC lingo comment. I think that's the first I've heard of, and it gave me a good giggle.
There are a lot of FERC lingo out there.
I'm sure. All right, well, with that, really, it sounds like there's a lot of issues that are being brought to light with Order 1920 and a lot of legal challenges. So I'm curious, and maybe Eric, you might be able to answer me on this. I'm curious as to how likely it is that Order 1920 will actually result in getting new transmission built. And if it is likely to get new transmission built, what would some of the key obstacles be to that result?
Good question. It's a question that many people are asking. I'll leave aside the legal challenges and what effect they may have, but I will note, first of all, that Order 1920 itself doesn't require the selection and development of any transmission project. People might be disappointed in that regard. Overall, however, I think Order 1920 is likely to result in transmission infrastructure being built that would not have been built or not built as soon as it would without this order. I'll give just a few reasons for that view and note some of the challenges associated with those. So first, as an obvious point, LTRTP requires long-term identification of transmission needs. That is not required now, and many transmission providers plan transmission using no more than a 10-year planning horizon, as I mentioned earlier, though there are some exceptions. Now, just the use of a longer planning horizon will result in identifying more transmission needs and more potential solutions. So again, just that increased scope of the planning horizon will itself tend to make solutions more likely to be identified and selected for development. But as I mentioned earlier, the longer-term planning horizon also means more uncertainty about needs 10 to 20 plus years forward. And this uncertainty will present some significant risks of needs changing, making selection and development of solutions challenging, with a need for safeguards to avoid regrets. And that reevaluation set of provisions in the order that Margaret talked about is part of those safeguards. Second, under the LTRTP process, all potential transmission needs will be considered in a more holistic way. And this means that the focus will include not only reliability and economic needs, but also public policy-driven needs, all considered together. And under current transmission planning in several regions, public policy planning tends to be contained in its own silo and is dependent on a separate process for the identification of needs and solutions. And similarly to the first point, the increased scope of the types of needs that will be looked at and the use of a more comprehensive, holistic way of planning should make selection and development of solutions more likely. But the use of a more holistic approach to identifying needs and solutions will introduce greater complexity into the analysis and decision-making process as people try to think through, what is the balance here in this transmission set of facilities for reliability benefits versus public policy benefits versus economic, et cetera. Third, Order number 1920 requires transmission providers to measure a set of 7 required benefits for selection of LTRTF under each long-term scenario, and then use those measured benefits to justify selection of solutions for development. I think this required and enhanced analysis of benefits should make transmission development more likely. Why? Because transmission providers and their stakeholders should have a more solid foundation for the decision to build. This will be important in the siting process as well, to have this justification there. And as I mentioned earlier, however, there could be some controversy around the weighing of benefits and their application to any particular solution that's proposed. And finally, the cost allocation provisions of the order give states more ability to agree on how to pay for evaluated and selected solutions. And that's a good thing in terms of getting an agreement to actually build something. States' involvement in cost allocation will be critical to the success of getting solutions built, especially in multi-state regions with different policies among the states. The challenge here will be getting agreement among the states on cost allocation and whether the states have a sufficient role in the selection process, and that goes back to some of the rehearing requests that we talked about. But overall, I do think this order will tend to result in more transmission infrastructure being built to achieve some of the purposes that people are looking to achieve. Liz, that's it for me.
Well, thank you for that takeaway on there. The one last question that I had, and Margaret, maybe you can take the lead on answering this one. Recently, we had confirmation filling the 3 vacant seats at the commission. And I was wondering what your thoughts were on the construction work in progress incentive and the proposed reestablishment of a federal right of first refusal for incumbent transmission owners, on whether or not those are going to be reviewed in the near future with the 3 vacant seats being filled.
Yeah, great question, Liz. So the federal right of first refusal, or ROFR, and the construction work in progress, or QIP, are 2 items that were originally proposed in the NOPR, but were not ultimately adopted in the Commission's final rule. So the Commission policy on both of those items stays as it is. 1920 did not change. I think it is likely that the Commission will address these items in a future rulemaking with the upcoming confirmation of the 3 vacant commissioner seats. For QIP, Commissioner Christie has been particularly vocal in his dislike of this incentive, which he views as being harmful to ratepayers. However, many see the QIP incentive as being very necessary to incent investment in transmission projects, which, as we all have seen, is a particular interest of both the Commission and the current administration. So it is unclear when and how the Commission will act on that item, but it's likely coming soon. For the ROFR, while the Commission declined to take action in this proceeding, the concurrence did specifically underscore that the final rule should not be construed as a lack of support for the concept of joint ownership or the potential federal ROFR to effectively encourage its use. So while it wasn't addressed in this proceeding, it was alluded to that it would be addressed in a new proceeding, an upcoming proceeding. So it's possible that both of those are coming. It's likely, though, that the Commission needs to do some additional fact-finding, and so we'll probably be issuing another notice of proposed rulemaking or notice of inquiry on both of those topics.
Well, thank you so much. So with that, I was just wondering if either of you have any really key takeaways that you might want to say before we wrap up for today. Eric, do you have anything?
Well, I would just say that we have a long compliance period ahead of us, relatively long anyways. We have 10 months to a year to comply with this in the regions. And so there's going to be a lot of activity. And although the order itself is quite prescriptive in some ways, it also does leave quite a bit of flexibility in other ways for the transmission provider and its stakeholders to develop proposals. And so I think that it's going to be quite interesting to see how those proposals get developed, and people who care about transmission planning and the results of it should be involved in that process.
Excellent. Thank you. Well, Eric, Margaret, thank you so much for joining me on today's episode. We've covered a lot today, from the details of LTRTP to the challenges of cost allocation and other things in between, and your insights have been incredibly illuminating. Yeah, I think the main takeaway that I'm really seeing from this is that it's going to take a lot to navigate the cost allocation, state agreements, legal hurdles, and ensuring stakeholder engagement. I think all of those are going to be very critical to the success of Order 1920. And, as you said, Eric, it sounds like this is going to take a collective effort from the transmission providers to the state entities and the stakeholders really across the energy sector to make this happen. Well, everyone listening, we hope this episode has given you some valuable insights into Order 1920 and its potential impact on the U.S. energy landscape. And please stay tuned for more discussions on the evolving regulatory environment and what it means for the energy industry. And with that, thank you for listening, and we look forward to having you with us next time as we continue exploring the ever-changing world of energy law in the U.S.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.